narrow and sometimes in a wider sense. The meaning of the word amendment must be interpreted on the basis of its use in our own Constitution. It would be purely speculative or conjectural to rely on the use of the word amcnd1 or amendment in the Constitution of another county, unless the entire scheme of amending section or article is also kept in mind. The position which emerges from an examination of the speeches in the Constituent Assembly docs not lead to any clear and conclusive result. The speeches show that our Constitution was to be an amendable one, and much rigidity was not intended. Pew 28-234. It is not possible to accept the argument on behalf of the respondent that the word amendment can have only one meaning. The word has several meanings, and the court will have to determine its true meaning, as used in the context of Article 368 by taking assistance from the other permissible aids to construction. A constitution is not to be construed in any narrow and pedantic sense. A broad and liberal spirit should inspire those whose duty is to interpret it. Pun 34-235 in Recipe. Bearer soles of motor spirit motor lubricants. Taxation Act 1938, 1939 FCR. 18. Attorney General for New South Wales. V. The Brewery Employees Union of New South Wales, etc. 1908. 6. CLR 469, 611-012, Fames by Commonwealth of Australia, 1936, AC 578, and BD's Ver. General Accident Fire and Life Assurance Corporation, 1948, 2 All ER 998, referred to. Apart from the historical background and the scheme of the Constitution, the use of preamble has always been made and is permissible. The word amendment has more than one meaning. The Constitution makers gave to the preamble the pride of place. It embodied in a solemn form all the ideals and aspirations for which the country had struggled during the British regime, and a constitution was sought to be enacted in a Sao Cordarusi with the GCNIW of the Indian people. It is not without significance that the preamble was passed only after the draft articles of the Constitution had been adopted, with such modifications as were approved by the Constituent Assembly. The preamble was, therefore, meant to embody in a very few and well-defined words the key to understanding of the Constitution, 235-236. Behram Khurshid Pesikaka's case, 1955, 1 SCR 613, Bashashar Nath v. Commissioner of Income Tar Rajasthan, 1959, Supasier 528 in Irikera. Education Bill, 1957, 1959, SCR 995, Rare v. HM, 1949, Dom LRR 199, John Switzman, Bir Sign, Frida Elbing, Attorney General of TA Prov, Ince of Quebec, 1957, Canada, LR 285, 326 SC, Re-Alberta Statutes, 1938, SCR, Wandred Dowing, Canada, Attorney General for Alberta, Fürstenberg, Attorney General for Canada, 1939, AC 117, Macaulay v. the King, 1920, AC. C1711 and Henry Berubari Union and Erconge of Enclaves, 1963 SCR referred to. It hardly makes any substantial difference whether the preamble is part of the Constitution or not. The preamble serves several important purposes. Firstly, it indicates the source from which the Constitution comes, VZ, the people of India. Next, it contains the enacting clause which brings into force the Constitution. In the third place, it declares the great rights and freedoms which the people of India intended to secure to all citizens and the basic type of Kesavananda, Phi, Kalala, Shi, at J, 15 government and polity which was IOB established. Farlam aft these, if any provision of the Constitution had to be interpreted, and if the expressions used therein were ambiguous, the preamble would certainly furnish valuable guidance in the matter, particularly when the question is of the correct ambit, scope, and width of a power intended to be conferred by Article 368 P. The contention that the preamble can be varied, altered, and repealed is an extraordinary one. ITQJ3Y be true about ordinary statutes, but it cannot possibly be sustained in the light of the historic background. The objectives resolution, which formed the basis of the preamble, and the fundamental position which the preamble occupies in our Constitution, it constitutes a landmark in India's history, and sets out as a matter of historical fact what the people of India resolved to do for molding their future destiny. It is unthinkable that the constitution makers ever conceived of a stag. So when it would be claimed that even the preamble could be abrogated or wiped out pure, where two constructions are possible, the court must adopt that which will see, hush smooth and harmonious working of the Constitution, and eschew the other which will lead to absurdity, or give rise to practical inconvenience, or make well-established provisions of existing BW nugatory. The conscientious and effective suggested construction have to be taken into account as has been frequently done by this court. Paitu Foribor, State of Punjab Vajab Singh, 1953, SCR 254, 264, Lianage for the Queen, 1967, IAC 259,